This meeting of the Escambia County Board of Adjustment for January 18, 2023 is hereby called to order. With 5 members present, we have a quorum. Will the clerk please swear in members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Horace? Yes. Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witness. Does anyone have any question regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for January 18, 2023 with the Development Services staff's findings of fact has been previously submitted to the board members. The chair will now entertain a motion to accept the BOA meeting package into evidence.
I'll make a motion.
We have a motion. We have a second.
I'll second it, Mr. Chairman.
We have a second. All in favor, raise your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of legal advertisement. Do we have a motion?
So moved.
We have a motion. We have a second.
Second.
All those in favor signify by raising your right hand. Passes unanimously. Members of the board, you have reviewed the resume and transcript of the Board of Adjustment meeting held on December 21, 2023. Upon your review of the transcript, are there any additions, deletions, or corrections? Seeing none, the chair will now entertain a motion regarding the reading of the resume of the Board of Adjustment meeting held on December 21, 2023. Do we have a motion?
December 21, 2022, you mean, right?
2022, I'm sorry, thank
Okay.
you.
So moved.
Second.
We have a motion, we have a second. Those in favor signify by raising your right hand. Passes unanimously. Sir, purpose of the Board of Adjustment.
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and are made a part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development orders for site plan approval are final unless overturned by a court of competent jurisdiction. The county may issue development orders and permits for properties in accordance with the decision of the BOA. However, If an applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. An applicant for relief from a decision of the BOA for said actions or any aggrieved party as defined by state law may seek review of such decisions by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an approval of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of the board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for the public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by the board of any administrative appeal, variance, or conditional use request. The chair will ask as each case is heard that any board member who has been involved in any ex parte communications regarding the respective issue to please identify themselves and describe the communication. Our first case is conditional use 2023-01 2301 Juneau Circle. Board members, has there been any ex parte communications regarding this case? Seeing none, does anyone have knowledge or information obtained from a visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this please come to the podium, identify by stating your name and address, and be sworn in?
Good morning. My name is Vivian Street. My address is 2031 Juneau Circle, Pensacola, Florida, 32526.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And were you provided with a copy of staff's findings of fact?
When
Yes,
I
I
email.
did. Yes, I have. I'm sorry. Nervous.
It appears that the staff and you are in concurrence or in agreement. Would you like staff to go ahead and present the case, and then if you have anything to refute anything, you could do so at that time?
Yes, I would like that.
Okay, thank you very much. Staff, would you please make a presentation?
Good morning. My name is Kimberly Wilson. I'm an urban planner too. So what we're looking at here is the current location map of the address. This is the,
Excuse me, could you speak just a little bit louder?
I'm sorry.
I don't believe the mic was close enough.
I'm sorry. So we're looking at the current zoning map. The current zoning is MDR, surrounding zoning is MDR as well. We're looking at the future land use map. The future land use is mixed-use urban. This is an aerial map showing the site location, the address of the home on Juno Circle. That's the picture of the front of the main dwelling. That's the public hearing sign, BOA sign. That is the rear yard looking south, where the proposed dwelling will be located on the site. And that's looking here again, rear yard looking east. And that's looking north, facing where the main dwelling is, where the accessory dwelling will be located. So, this applicant, they are requesting conditional use for an accessory dwelling on a lot that's less than 1 acre. They have 0.53 acres. Going to criterion A, finding of facts. From what the applicant provided, the proposed dwelling could be conducted in the same manner as the main dwelling, since it would be just an accessory dwelling to the main one. Criterion B, as far as facilities, the proposed accessory dwelling will utilize the same utilities as the main dwelling. Criterion C, as far as ingress and egress, is getting to the particular accessory dwelling. They do have access on both sides of the home, east and west. Yep. Criterion D, as far as nuisance and hazards, based on the applicant, they will, it won't be any nuisance or hazards associated with the proposed use. All requirements must be met for new construction per the LDC. Criterion E, solid waste. Applicant, solid waste containers will be available and located in the rear of the main entrance if needed. Criterion F, screening and buffering. Screening and buffering will be provided if need be, if as long as they don't have an impact on the adjacent neighbors. Criterion G, signs and lighting. Applicant says, states that their HOA does not allow for signs or lighting to negatively affect neighbors or traffic safety. No signs are allowed or lighting again. Criterion H, site characteristics. The size, shape, and location and topography of the site appears to be adequate to accommodate the dwelling, the accessory dwelling. They would have to meet such requirements such as setbacks, height, distance, and distance requirement, and that'll be confirmed and reviewed during their submittal, their site plan review. Criterion F, use requirements. There are no additional conditional use requirements. In conclusion, staff findings, we find that they do meet the approval of the conditional use, or we do recommend the approval for the conditional use as requested.
Board members, any questions of staff?
I have a question. Excuse me.
Yes.
Did I see a survey showing the dwelling, or was that?
Yes,
Okay.
this one included.
So it's, according to this survey, it'll be 12 feet off the side setback and a good,
They'd have to be 12 off each
Okay.
side and 20 feet off the rear.
and have they spoken to you as far as, what this building's gonna look like? Is it gonna have the same facade, the same, design as the original, structure?
Not to me. Maybe they can explain the facade and things of that nature. They did say that it would be approximately 576 square feet.
Okay,
But as far as design or facade, no.
okay. Ms. Street, could you come to the podium? What is your, the new accessory building? Do y'all have any type of design of what that's gonna look like, or?
Design on the outside?
Yes,
Yes, we do. It's hip roof. I don't know.
will it have the
architecture.
same colors, the
Oh,
same?
yes, the same colors as
Okay.
our home, the same
Uh-huh.
roof colors, the same outside color, and a hip roof design.
The roofing tile will be the same, and anyway,
The
it's
same
gonna,
color.
it's gonna be in harmony with your
Yes,
existing
it
main
is.
structure?
Uh-huh.
Okay. And what is the reason for wanting this, accessory dwelling?
We want to have this ADU to meet the needs of our young adult grandson who has a disability. We are of the opinion that he needs this for meeting his independent living experience, but we feel that it's imperative and very important that we provide him with a independent but safe environment.
Well, this, structure, I mean, it's an accessory dwelling. Will it have like a kitchen and a bathroom and a
Yes.
bedroom, you know, like a
Yes.
regular house?
Yes,
Okay.
yes, a kitchen, bathroom, bedroom,
Okay.
living room area.
Okay. And I guess my last question is for staff. When they sell this house, that accessory dwelling, can it still be used as an accessory dwelling after they sell it to someone? Does it
Yes.
run with the land?
That conditional use will run with the land.
Okay, that's what I need to know. Thanks. Thank you.
Thank you.
I have a question for staff also. The ingress and egress, is there gonna be enough room to be able, I presume we're not talking about a car going back there or a driveway or anything, are we?
Correct. No, there's not room to run another, a driveway extension or a parking area for this is not proposed on the plans we've received. So it would be a walkway between the house and the accessory.
Okay. And help me, if I recall in these kind of cases, there's a ratio for the size of the principal dwelling and the accessory dwelling.
Correct. This would need to be under 50% of the size of the primary dwelling, and it is.
Okay.
I have a question for the board also. Could this structure be used as a rental property later on?
So we don't regulate that. The county doesn't. In fact, the state preempts us on that sort of thing as far as if you're talking short-term rentals. But as far as the structure, the idea of an accessory dwelling, that's the only thing we have on that. We don't in any way regulate any home as far as if it's owner occupied or rented.
Thank you.
Ma'am, I guess I have one more. From what you have told us, I'm presuming that you intend this as a long-term dwelling for your grandson, is that right?
Yes, I do.
Okay. Thank you, ma'am.
Board members, any other questions of staff? Any questions of the applicant? Seeing none, the chair would entertain a motion regarding this item. If for any reason you do not adopt staff's findings of fact, please state your reasons. Do we have a motion?
Mr. Chairman, we didn't have any other persons wishing to testify
We
on
did
this.
not, but if there are others, we would get you to fill out a blue form and come forward. I see none. So we're back to, the chair would entertain a motion regarding this item.
I'll move that we accept staff findings of fact.
We have a motion by Marty. Do we have a second?
I'll second the motion, Mr. Chairman.
We have a second by Michael.
I would like to add to that motion, that the accessory dwelling be similar in color and design, as the main structure. I think that's important.
I'll accept that.
We have
And would you specify when you say accept staff's findings, you're
With the
making a motion to approve? Is that correct?
With,
yeah, you
With
made a
the-
motion to approve, and an amendment was added,
okay.
and you have accepted that to the motion.
I move that we accept staff facts, findings of fact, and include the additional requirements for the board.
Do we have a second to that amendment?
Mr. Chairman, I'll second it with the understanding that the accessory structure will be, adopt the features of the original dwelling in its appearance as best that can be done.
And that,
May I say something? Let's be clear. I want to be clear because we get the motion correctly. There's a difference. Our code got a complete difference. There's a difference between a structure and an accessory dwelling. Two different requirements now. So this is an accessory dwelling, which is going to be like a house. An accessory structure could be a shed. This is not going to be no shed. This is going to be a ADU, like a small house dwelling unit on a lot. So I want to be clear with the terminology and the nomenclature going forward.
and if I may, just for information purposes only, as you all know, we don't regulate or enforce or get involved in any way with any sort of homeowners association regulations and rules. That's completely a civil matter. As you go through this neighborhood, all the houses are of a similar design, so there's probably some sort of regulations within their HOA, that private agreement regarding those design requirements.
Les, I think we're going to need to repeat the motion in total, and Counselor, if you would kind of observe and see, make sure we're getting it correct.
All right, let me try this again. I move that we accept staff's findings of fact and approve the structure as a
The accessory dwelling.
as an accessory dwelling with the requirements that it meets the exterior features of the existing residence.
We have a motion. Do we have a second?
I'll second it, Mr. Chairman.
We have a second by Michael. Any further discussion? Seeing none, those in favor of the motion signify by raising your right hand. It passes unanimously. You're fine to go forward with developmental department. Now, as I understand it, our second applicant is not able to be here because of delay coming from Texas, I believe. And so we'll delay that until another time.
Our next meeting is going to be held in this room on February 15th at 8:30. The same advertisement will be sent out, as well as postcards will be sent out to the same residents to advise them of the change.
Thank you.
And the applicant had requested that.
Who will bear the cost for the delay?
Applicant will.
Okay.
Any discussion items? Seeing none, without objection, we stand adjourned.